Judge, can you hear me?
Yes, sir.
Okay, good.
All right, we ready to start this afternoon's docket, or do you still need time to? Do you have that microphone? Is that microphone over there, Fabio?
Can you hear me?
Yes, I can hear you. Yeah.
Okay,
Usually we set it on the podium there so that
looks like it's been dropped.
Is he ready?
Whenever you are.
Great.
perfect. Yeah, do that, and then if you don't mind, Fabio, go ahead and angle that camera up, or I won't be able to see the attorney.
Yes. Can you hear me on this one?
Yes, sir.
Okay,
I don't know if it's coming from that, but I can hear you.
okay, good.
Perfect.
All right.
Thank you, sir.
Yes, sir.
Hey, Fabio?
Yes, ma'am.
Oh, never mind. Got it. Okay.
Monty, I've talked to this, you're good, you know what's happening today. Mr. Turnage.
And counsel, I'm ready whenever y'all are.
Yes, sir.
Yeah.
It's coming out.
Who do we have first, Mr. Smith?
Brett Turnage.
All right, this is cause number CR 24-154, State of Texas versus Brett Lawrence Turnage for arraignment. Go ahead, Mr. Smith.
Judge, we understand the charges, he understands the range of punishments, name spelled correctly, we'll wait for the reading, enter a plea of not guilty, ask for a pretrial setting.
All right, court finding that Mr. Turnage has waived the formal requirements of arraignment, enters his plea of not guilty into the record. Court sets this matter for pretrial hearing. You want to do September 3rd?
Or
All right, court sets Mr. Turnage for pretrial hearing September 3rd at 1:30. If Mr. Turnage makes bail, then his hearing will be at 9 a.m. Who would you like next?
Jacob Hall.
Court calls cause number CR 24-136, State of Texas versus Jacob Thomas Hall for arraignment. Go ahead, Mr. Smith.
Just wait formal reading, his name spelled correctly, understands the charges and range of punishment, and a plea of not guilty at this time, ask for a pretrial date.
All right, court finds that Mr. Hall, waiving the formal requirements of arraignment, enters his plea of not guilty into the record. Court sets this matter for pretrial hearing on September 3rd at 1:30 PM.
Your Honor, the family has reached out to our office and asked that if Mr. Hall were to make bond, that there be no contact condition, any member of this family.
All right, and have conditions of pretrial release been signed by either the magistrate or this court? Are you aware?
Not that I'm aware of, Your Honor.
Let's take a moment and we'll look at that.
Hold on.
All right, I do see that this court has issued amended conditions of pretrial release that was signed on July 1st. And condition number 4 and number 5 have been checked, indicating that the defendant shall not communicate in any manner directly or indirectly with the alleged victim in the case. And just for purposes of the record, who is the alleged victim in the case? Is it the victim that has been identified in the indictment, or is that a pseudonym?
It should be the victim identified. There's going to be a couple of different ones, Your Honor. There's the indicted case, and then there's some unindicted cases as well. The victim in the indicted case is Miss Riley Mercer.
Okay, I'll ensure that the amended conditions reflect her name in the conditions of pretrial release. As for the unindicted cases, unless there's an appointment of counsel on those, I'm not sure if he's been magistrated by another magistrate or if I have jurisdiction.
And Your Honor, Mr. Schmidt has been to those, they just haven't been brought.
Okay, and if there's a request, if there's a different victim, is there a different, then I'll need that information forwarded to my office and make sure to include Mr. Schmidt so that if the court does issue conditions of pretrial release, I'll have a named victim and we can get those executed with notice to Mr. Hall and Mr. Schmidt.
Yes, sir.
Any questions or any issues on that, Mr. Schmidt?
This time, no, there's a potential for an objection depending on what the state's requesting. But I'm unsure who those names would be. So if they forward that information to us, we'll definitely review it.
All right, thank you, Mr. Schmidt.
Yeah.
Who's next?
Israel Torres.
Israel Torres, cause number CR 24-153 for arraignment. Go ahead.
Judge, we're awaiting formal reading. He understands the charges and his name spelled correctly. Enter a plea of not guilty for today's purposes. We'd ask that it be set for pretrial, but in addition on that pretrial date, just to give the state notice, Mr. Torres is likely to accept the state's offer and we're prepared to plea on the next court date.
Thank you.
All right, court finds that Mr. Torres, having waived the formal requirements of arraignment, enters his plea of not guilty into the record. Court will set this matter for pretrial on.
Could I have an earlier date, like perhaps next week, Judge?
I can do, you want September, I'm sorry, you want August 13th? I'm out next week. And so,
August 15th, if that's the earliest, we'll take it. Yes, sir.
yes, Thursday's the earliest, but
I can come on Thursday if the court, if the state can be ready.
Yeah, I think we could probably make one for Thursday.
all right, court will set then. Mr. Torres, do you want to set for plea, Mr. Schmidt?
That'll be fine, Judge.
All right, court sets Mr. Torres for plea before the court August 1st at 1:30.
Oh. Thank you. Appreciate it. Ronnie.
All right, who's next?
Tony Austin.
This is cause number CR 22-166, State of Texas versus Monty Travis Austin. Hearing on his motion to revoke. Go ahead, Mr. Schmidt.
Judge, we're gonna ask for a reset. I've conferred with Mr. Hartwell. It appears that Mr. Austin has been charged with 3 additional felony charges that I'm not sure if the state has the cases at this point. I haven't reviewed it. They're obviously unindicted, but we need to get all of that business resolved at one time if we could.
Any objection from state?
One charge that was received, but I'd like to see what law enforcement is going to deliver on the other potential charges and see if those are things that all wrap up together possibly.
All right.
And Judge, I'm having a real difficult time hearing the state.
Repeat that, Mr. Hartwell.
No offense for the state, Your Honor. I'm aware of one case that has been delivered to our office, so I'd like to get my eyes on the other potential cases, see what we're looking at, see if there can be global resolution to everything.
All right, court will set Mr. Austin then for the contested docket, evidentiary docket on September 26th. That's a Thursday, Mr. Schmidt. I'm
That's
gonna go set it out to September, give you all some time to try to get those cases in and reviewed.
Yes, sir. Oh, okay.
Who would you like next?
This is Robert Driscoll.
Cause number CR 24-132, State versus Robert Wade Driscoll for arraignment. Go ahead.
Judge, we understand the nature of the charges. His name is spelled correctly, understands the range of punishment. We waive that formal reading, enter a plea of not guilty, ask for a pretrial setting.
All right, the court finds that Mr. Driscoll, having waived the formal requirements of arraignment, does enter his plea of not guilty into the record. Court does set this matter for pretrial hearing on September 3rd. At 1:30, should Mr. Driscoll make bail, then his hearing will be on that same day at 9 a.m.
They stand for mine up here. I'll keep talking. Sounds good.
Did you say this is Mr. Jeffrey Walker?
Yes, sir. And Judge, we've reached an agreement with the state on Mr. Walker's writs. I could read that into the record for the court's pleasure.
Go ahead, please.
We've agreed that on the injury to a child charge, that it be a PR bond at the same amount. And that on the assault occlusion, state and they've agreed to $25,000 cash or surety on that one.
That's correct, Your Honor.
Okay. All right, the court will review his criminal history in the PSRS, and then I will make a decision on y'all's agreement.
Yes, sir. Thank you. Thank you,
All right.
Judge.
All right, Mr. Schmidt, who do you have with you?
Cody McCoy.
All right, this is cause numbers CR 23-133, 23-111, CR 23-112, State of Texas versus Cody Lee McCoy. Is Mr. McCoy entering a plea today?
Yes, we're prepared to enter a plea on CR 23-111.
All right, Mr. McCoy, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
Thanks, sir. You can lower again. All right, your name is Cody Lee McCoy, is that correct?
Yes, sir.
And Mr. McCoy, are you a United States citizen who reads, writes, and speaks English?
Yes, sir, I am.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt as your attorney?
Yes, sir, I am.
You feel like you've had enough time to discuss the case with him, have all of your questions answered, and that you understand everything that you've read and signed today that's part of your plea agreement?
Yes, sir.
Mr. Schmidt, do you believe Mr. McCoy to be competent?
I do.
You've explained to him his rights as they pertain to this case?
Yes, sir.
All right, and do you also believe that he's entering into this plea intentionally, knowingly, and voluntarily?
I do.
All right, and what are we doing on clause number 112?
The language is that it's being 1245. Okay, yes, sir.
All right, Mr. McCoy, you are charged by indictment in cause number CR 23-111 with a third-degree felony offense of unlawful possession of a firearm by a felon. That does carry a range of punishment of not less than 2 years or more than 10 years confinement. In the Texas Department of Criminal Justice, it also carries a possible fine not to exceed $10,000. I see the plea agreement in your case is that upon your plea of guilty, the state's recommending that you be convicted of this offense, that you be sentenced to 6 years confinement in prison with a $1,000 fine, in addition to court costs and reimbursement fees. And as part of the agreement, the state is asking the court to dismiss a few, one indicted case and 2 unindicted cases, a taking wildlife resources without consent, which is indicted in cause number 112, and then also 2 unindicted cases, one a criminal trespass and the other a tampering or fabricating with physical evidence. Also, as part of this plea agreement, you would forfeit the weapon seized, and you would also receive your credit for the time that you've already been in jail, which is 272 days. Is that your understanding, Mr. McCoy?
Yes, sir. Exactly to the T is what me and Mr. Schmidt talked about.
All right, excellent. All right, understanding the plea agreement, understanding the range of punishment, Mr. McCoy, how do you plead to unlawful possession of firearm by felon?
Plead guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
And has anyone threatened, forced, or pressured you to plead guilty?
No, sir. Not the least bit. Not the least bit.
All right, then the court will accept the defendant's plea of guilt at this time. Mr. Schmidt, any objection to the stipulation of evidence?
No objection.
All right, the stipulation is admitted and the court does take judicial notice of the defendant's judicial confession. Is there anything further from the state?
Nothing further.
Anything further from the defense?
Yes, sir. If I could briefly call Mr. McCoy to testify.
Yes, sir, go ahead.
Mr. McCoy, you understand that you're under oath already? You're
Yes,
still
sir.
under oath. Now, you pled guilty to these charges and admitted culpability in the other indicted charge. You understand that today?
Yes, sir.
When you were arrested for these offenses, did you have any other individuals with you?
Yes, sir.
Were they arrested as well?
Yes, sir.
And based on your plea today, are you telling the court that you're guilty and that you are responsible for the criminal acts that you and your co-defendants were charged with?
Yes, sir.
Did the other individuals that were arrested along with you, did they have anything to do with any of these offenses?
No, sir. They did not.
And the firearms that were recovered, those belong to you?
They belong to me. Yes, sir.
No further questions.
Any questions from the state?
Yes, Mr. McCoy, well, the firearms belong to you. Did any of the other folks with you possess them, hold them, carry them, anything like that?
No, they knew nothing about them, sir.
Anything further, Mr. Schmidt?
No, sir.
All right, and then Mr. Schmidt, do you have a copy of the stipulation there with you?
I do, sir.
Can you just show it to the screen? All right, thank you, Mr. Schmidt. All right, then, based on the evidence reviewed by the court finds that there is sufficient evidence to convict the defendant of this offense. The court this day will follow the plea agreement. Court hereby convicts Cody Lee McCoy of the third-degree felony offense of unlawful possession of a firearm by a felon. The court assesses his punishment at 6 years confinement in the Texas Department of Criminal Justice, orders him to pay a $1,000 fine, $290 court cost, $85 in reimbursement fees. The court does dismiss 2 unindicted cases of criminal trespass and tampering or fabricating physical evidence, and also indicted cause number CR 23-112, taking wildlife resources without consent. Further, the court does order the weapons seized in this matter to be forfeited to the state. The court also awards Mr. McCoy the time that he has already spent in jail of 272 days. Mr. McCoy, you hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and condition of the sentence. I'm gonna have you step over to be fingerprinted. Once you are released from TDC, Mr. McCoy, if you've not paid off your fines and court costs and other fees, then you need to report to the courthouse and make arrangements to take care of those, okay?
Yes, sir, will do.
And Judge, I would note that in our stack of papers, I did not see a motion to dismiss the other indicted 1112 case. I'm not sure if the court has that or not.
I don't have that either.
Okay, I just wanted to bring it up to the state that way. We don't miss out on that.
Yes, sir, I'll check for that. And I'll figure out this pretty well.
All right, it's noted, Mr. Schmidt. Thank you.
Thank you.
Of course. Are you ready on yours?
You can keep rolling if you want to.
Oh, we have one left.
Yeah, the second officer.
The pressure.
All right, Mr. Manning, who are you ready on?
Judge, we're ready on Mr. Glasgow.
All right, court calls cause numbers CR 23-215, CR 24-19, CR 24-20, State versus Michael James Glasgow. Is this a plea today, Mr. Manning?
Yes, Judge, as you are aware, back on July 11th, we were planning to go forward with a plea, but we didn't have restitution numbers at that point in time. We have since been able to negotiate an agreed restitution amount of $15,450, and it's going to be on CR 23-215. CR 23-215. This will be a plea to resolve CR 23-215, CR 24-19, CR 24-20, and all other unfiled cases.
All right, very well. Mr. Glasgow, sir, if you'll raise your right hand, I'm going to place you under oath. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thanks, sir. You can lower your hand. All right, your name is Michael James Glasgow. Is that correct?
Correct.
And Mr. Glasgow, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
Negative. No,
Sir?
sir.
No.
No, sir.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning as your attorney?
Yes, sir.
You feel like you've had enough time to discuss your case with him, have all of your questions answered, and that you understand everything that you've read and signed today as part of your plea agreement?
Yes, sir.
Mr. Manning, do you believe that Mr. Glasgow is competent to enter into this agreement? And if so, do you believe he's entering into this agreement intentionally, knowingly, and voluntarily?
Judge, he is competent and he is entering into this agreement intentionally, knowingly, and voluntarily.
And you have explained to him his rights as they pertain to this case?
I have, Judge. We've discussed this case and all other cases associated, as well as possible defenses or other resolutions, and I believe he has weighed those and reached this decision voluntarily.
All right, Mr. Glasgow, in cause number CR 23-215, you are charged with the second-degree felony offense of burglary of a habitation that does carry a range of punishment of not less than 2 years or more than 20 years confinement in the Texas Department of Criminal Justice. And in fact, in cause number CR 24-19, you are charged with the same offense, a second-degree felony offense of burglary of habitation that carries the same range of punishment. I see that there are plea agreements in your cases here, specifically in cause number CR 23-215. The state's recommending that upon your plea of guilty, that you be convicted of the offense, that you be sentenced to 8 years confinement in prison, restitution in the amount of $15,450, court costs of $290, and reimbursement fees of $125. And the state is agreeing to dismiss several cases: an unindicted theft of property, an unindicted theft of a firearm, an unindicted criminal mischief, an unindicted evading arrest or detention with a previous conviction, and an indicted cause, CR 24-20, unlawful possession of firearm by a felon, all to be dismissed, and that your sentences would run concurrent to one another, meaning as you're serving the sentence on one, you will be serving the sentence on the other. In cause number CR 24-19, the same plea agreement, 8 years is the recommendation with your time running concurrent. In addition, you would have court costs and reimbursement fees. In that case of $290 court costs, $85 reimbursement fees. And in both cases, on both sentences, you would receive the time that you've already spent in jail of 354 days. Is that your understanding of the plea agreement?
Completely, yes, sir.
Was there a weapon seized or in this matter on the unlawful possession of firearm by felon in CR 24-20?
Your Honor, I believe that was part of the theft of firearm case that was rejected. I think that property was, if it hasn't been returned, it's going to be returned to the victim in this case.
That's correct.
All right, thank you, John. All right, so Mr. Glasgow, understanding the plea agreements, understanding the range of punishment, this time I'm going to ask you, how do you plead to each one of these crimes of burglary of a habitation in each cause?
Guilty.
Are you pleading guilty to each cause?
Yes, sir.
And Mr. Glasgow, has anybody threatened, forced, or pressured you to plead guilty?
No, Your Honor.
And you are pleading guilty today because you are in fact guilty of committing these offenses?
Yes, sir.
All right, the court does accept the defendant's plea of guilt in each case. Mr. Manning, any objection to the stipulation of evidence?
No objection to stage one in either cause.
All right, stipulation of evidence is admitted and the court does take judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, just that state has been contacted with their report.
Thank you, Mr. Harwell. Anything further from the defense, Mr. Manning?
Judge, we were unable to hear the state's announcement there.
Mr. Hartwell said that he has been in contact with the victim in this case and they are supportive of this plea.
Yes, Judge.
All right, and is the stipulation the same in each case, Mr. Hartwell?
Essentially, Your Honor, all the events took place on the same day, just different residences.
I may need to see the stipulation of evidence for CR 24-19 in just a moment, Mr. Manning.
Yes, Judge, I'll prepare that.
All right, Mr. Manning, if you can show me the stipulation of evidence for 19.
Yes, Judge.
All right, thank you, sir. All right, based on the course review of the evidence, I find that there is sufficient evidence to convict the defendant of these offenses. The court will follow the plea agreement today. In cause number CR 23-215, the court convicts Michael James Glasgow of burglary of a habitation, a second-degree felony, assesses his punishment at 8 years confinement in the Texas Department of Criminal Justice, orders him to pay court costs of $290, reimbursement fees of $125, restitution in the amount of $15,450. In addition, the court does dismiss the cases outlined in the judgment under section 1245, including cause number CR 24-20, unlawful possession of firearm by a felon. And the court will order that this sentence run concurrent with the sentence imposed in cause number CR 24-19. Court does award Mr. Glasgow 354 days credit towards this sentence in this matter. In cause number CR 24-19, this court hereby convicts Mr. Michael James Glasgow of burglary of a habitation, second-degree felony, assesses his punishment pursuant to the plea agreement at 8 years confinement in the Texas Department of Criminal Justice. The court orders his sentence to run concurrent with cause number CR 23-215. In addition, the court orders him to pay court costs of $290, reimbursement fees of $85, and awards him his time spent in jail previous at 354 days. Mr. Glasgow, once you're released from TDC, if you've not made arrangements to pay off your fines, fees, restitution in those matters, then I need you to report to the Van Zandt County Courthouse, and you'll meet with them and they can discuss with you what your options are about discharging those. All right?
Yes.
All right, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'll have you step over to be fingerprinted. Good luck to you, sir.
Thanks, sir.
All right, who's next?
Judge, this is Mr. Collard, Anthony Collard.
All right, this is cause number CR 21-110, State of Texas versus Anthony Dale Collard on motion to revoke. Go ahead, Mr. Manning.
Yes, Judge, this is a recent appointment on the motion to revoke. Additionally, Judge, my client was taken to the hospital last week with a heart condition and is still undergoing treatment. I'm seeking to also gather some witnesses, and that's been difficult with him being in the hospital. So we would request a reset on this motion to revoke.
Any objection from the state?
No,
All right, there being no objection, the court will grant the request to continue. I think 30 days is sufficient, Mr. Manning, August 29th.
Judge, that should work.
All right, the court sets Mr. Collard's hearing on the evidentiary docket August 29th at 1:30. Who would you like next?
Judge, we still have some paperwork for Mr. Mata and Mr. Young. Looks like he was just brought in. So if I may just have a couple minutes to go over their paperwork.
Yes, sir. And so the only other one that you have would be Mr. Tatum. Is that correct?
Yes, Judge, I was recently appointed Mr. Tatum and have not met with him since that appointment. I represented him previously, I believe, in 2022. And I was only able to print one of the two indictments that are listed on today's docket. Discovery in the evading arrest was not released. So we may need to pull up that indictment in order for us to do arraignment on him.
Okay. All right, go ahead and take your time. I will have that pulled up and ready. Just let me know when you're ready to go. And also, Mr. Schmidt, if he gets ready on Liza, Langley, or anyone else, just let us know.
Yes, Judge. Judge, it looks like Mr. White may be ready.
Okay, Mr. White, are you ready?
Yes, Your Honor.
All right, Joshua Ernest Hogue, CR 24-140 for arraignment.
That's correct, Your Honor. We've had an opportunity to go over the indictment. Our name is spelled correctly. We don't need the state to read it to us. We're entering a plea of not guilty at this time.
All right, court finding that Mr. Hogue has waived the formal requirements of arraignment, enters his plea of not guilty into the record, and sets this matter for pretrial hearing. You want that September 3rd date, Mr. White?
Can we make it? Is there a possibility it could be that Thursday? Or y'all not having court out here on that Thursday?
That Thursday, you mean the 5th?
The 5th.
No, sir, I'm out for training that week.
Okay, well, we'll do it.
We could make it earlier. We could do August 27th. I just want to make sure I gave you enough time.
Well, I probably need some time. September 3rd.
Yes, sir.
And Your Honor, my client wound up filing a motion for a bond reduction. I'm prepared to go ahead and go forward on that. The actual bond that he
Let
has set,
me ask, did you serve that on the state and request a hearing? If not, then what we'll need to do is set that for a hearing, make sure that they get a copy of it so they have notice of it. And I've got time between now and, the next time we're here to set the motion for bond reduction hearing.
Okay. Well, I guess that's what we need to do then, because I'm not aware of whether or not the state got served on it, because I didn't actually file the motion myself.
Do you know if y'all received any notice of a motion to reduce bond?
I spoke with Mr. White. I want to say yesterday, and he did tell me about it. I haven't been able to. I can look and see if we got one.
See if you have it in your system to see if you received it. If not, then Mr. White, you may need to file the motion and serve it on the state and then request a hearing on it.
If that's the case, I have no problem redoing any of that. I just didn't want to lose the opportunity if we had a chance today.
Your Honor, I don't have a copy of it in my phone.
Okay, so Mr. White, if you'll either find that motion, serve it on the state, or draft a new motion. And then if there's no agreement on it, then request a hearing and we'll get it set. We can get it set as early as week after next.
Okay, thank you, Your Honor.
You're welcome.
I believe that's all I have in front of you today.
Yes, you're excused. Thank you, Mr. White.
Ready? Mr. Smith's coming up, Judge.
Okay. Is this Ms. Langley?
It is just.
All right, court calls cause number CR 20-150, or I'm sorry, CR 20-15, State versus Liza Ann Langley. Motion to revoke. Go ahead, Mr. Smith.
Judge, we're gonna ask for an additional setting on Miss Langley. She has some holes out of Dallas County, which are alleged in the state's motion. Need more time to work with Mr. Hartwell or Mr. Hernandez to see if we can come to a resolution. Not certain what Dallas County is trying to do, but be difficult for us to resolve it without trying to get the whole package done.
Any objection from the state?
No.
All right, there being no objection, the court sets Ms. Langley for August 29th at 1:30. All right, court's going to stand in recess and give Mr. Manning time to meet with his clients.
Got it. Yes, sir. Your Honor, we're ready.
All right, Mr. Manning, who are you ready on?
Judge Ready,
Say that again. I couldn't hear you. Say that again. Couldn't hear you.
sorry, Judge, we're ready on Mr. Charles Young.
Charles Young. All right, cause number CR 22-345. State of Texas versus Charles Brandon Young. Mr. Young, come on up.
I'll talk over here. Come on.
All right,
Come on, let's go. That's it. Let's go. You had your chance.
we're gonna give her a chance to.
Bring him back to us. Oh, he doesn't want to talk anymore.
All right, Mr. Manning, is it my understanding that Mr. Young and the state have reached an agreement wherein the state would be withdrawing its motion to revoke? It's going to amend the conditions of community supervision for Mr. Young to place him on the intensive supervision and amend him for repayment of attorney fees?
Yes, Judge, that is correct. I've explained that to Mr. Young. He agrees to that. Also spoke to Mr. Officer Matura, and she's been able to answer Mr. Young's questions regarding his amendments.
Okay, tell me just in summary, Mr. Manning, why should the court accept this agreement and place Mr. Young back on community supervision?
Yes, Judge, Mr. Young was reporting out of state, and there was some difficulty with his reporting out of state. Additionally, Judge, he did have some positives, I believe 2 positives for drugs. And I think with this ISP program, it's going to be able to provide with the tools. Mr. Young's a dual diagnosis situation. I think that's going to provide with the tools that he'd be able to continue on his journey of sobriety as well maintaining his mental health status. And I think ISP is the intermediate step before we get to Mr. Young having to go to prison. So I think based on the work that Mr. Young's put into his probation as well as continuing his sobriety, I think he at least deserves a chance to show the court he is capable of doing what the court's ordered in this case.
All right, and I'm assuming that probation is supportive of this agreement?
Yes, Judge. I spoke to Mr. Gann, or Officer Gann, as well as Officer Matura, and they agreed that this would be the best fit for Mr. Young to proceed if he's going to proceed on probation.
All right, and Mr. Young, I want to hear from you now. So what's going to be different this time?
I'm gonna be a little bit more conscious in the way that I move and the things that I do, and I take medication, so I know that most of the time that whenever I'm not taking my medication, that causes me to relapse basically and to use something to try to substitute whatever it is that my medication is doing for me. I was having problems with it in Florida, not being able to actually get like a prescriptive doctor, or I guess you could say, you would want to say, or get one specific doctor so I could get my medication prescribed to me. That was what was my real problem, which is the cause of both my dirty urines. I basically was trying to self-medicate myself, and it just wasn't a smart thing to do.
And do you have that settled now? Do you have a doctor that's going to be able to provide you the medication that you need?
Well, what I did was, because I noticed that I was having a lot of issues, well, family issues in Florida and everything like that, I wasn't being able to find a doctor, and I wasn't in Florida long enough to find a doctor, which is the reason why I transferred my probation back to Texas. And I'm basically trying to get stable here in Texas now. And that way I'll be able to find me a doctor and everything like that. Right now, I'm taking my medication here. And that's another subject I gotta talk to my lawyer about as far as before I leave this facility. I wanna make sure that we have the proper prescriptions and everything like that so I can get back on my medication. I'm already on it, been on it for the last month and a half, and I'm doing pretty good.
And Judge, I'd also offer the court that Mr. Young has a sponsor down in Bay City who has explained that they will be accepting Mr. Young and giving him kind of his transition from jail into the free world. And it's Mr. Young's intention to as I said, get an apartment down there and get, like you said, stabilized, get him some roots put down, and hopefully be able to finish up his probation, as ordered previously.
All right, thank you, Mr. Manning. All right, thank you, Mr. Young. All right, the court's going to grant the state's motion to withdraw its motion to revoke. The court will continue Mr. Young on community supervision. The court will amend his conditions to include placement on the intensive supervision program and also amend for payment of the court-appointed attorney fees. All right, Mr. Young, get out and get yourself reestablished and stay on top of your issues so that you don't end up back here, okay?
Yes, sir. Thank you. I appreciate what you're doing for me.
You're welcome. All right, have a good day.
You too.
Judge, next ready on Mr. Mata.
All right, Christopher Jean Mata, CR 20-261. Mr. Mata, sir, if you'll raise your right hand, I'm going to place you under oath. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Sir.
I think so. You can lower your hand. All right, your name is Christopher Jean Mata, is that correct?
Sir.
And Mr. Mata, it appears that you were last in this court on your motion on your original charge on August 12th of 2021. You pled guilty to the state jail felony offense of possession of a controlled substance of penalty group 2 less than 1 gram. The court heard the evidence that day, found that there was enough evidence to convict you, but the court followed a plea agreement and placed you on deferred community supervision for 2 years, also assessing a $2,500 fine. It was during your period of community supervision that the state filed a motion to adjudicate in June of 2022. Have you had enough time to review that motion with your attorney, Mr. Jonathan Manning?
Yes, sir.
And are you comfortable that you've had enough time to discuss your case with him and that you've had all of your legal questions answered?
Sir.
Are you pleased with Mr. Manning and the work he's done for you?
Yes, sir.
Is there anything about your plea agreement that you do not understand?
No, sir.
Mr. Manning, do you believe Mr. Mata to be competent today? And also, does he waive the formal reading of the state's motion to adjudicate, and does he intend to enter pleas are true to all counts?
Judge, he is competent. He is waiving the reading of the motion to revoke, and he is pleading true to all counts.
All right, Mr. Mata, then I'm going to ask you at this time, how do you plead to counts 1 through count 10 as alleged? Are those counts alleged true or not true?
True.
And you're telling me that those are true because in fact, whatever is alleged is true. Your actions in those counts is true. Is that right?
Yes, sir.
And Mr. Mata, has anybody threatened or forced you to plead true to any of these counts?
No, sir.
All right, the court does accept the defendant's plea of true to each count as alleged. Mr. Manning, any objection to the admission of the defendant's waiver of rights and plea of true document?
No objection.
All right, that is admitted, and the court does take judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank
Anything further from the defense?
Rest and close, Judge.
All right, court. Having found that, having heard the testimony of Mr. Mata, finds that he has violated the terms and conditions of his community supervision, the court finds all 10 counts to be true. On the basis of that, the court does find that there is a plea agreement between the defense and the state. Court will follow that plea agreement today. The court hereby adjudicates the guilt, convicts Christopher Jean Mata of possession of a controlled substance in penalty group 2 less than 1 gram, assesses his punishment, revokes his community supervision, and assesses his punishment at 7 months confinement in the Texas Department of Criminal Justice State Jail, orders him to pay the balance of his financial obligations, and the court awards him 95 days credit towards his sentence for the time that he's already spent in jail on this cause.
Judge, if I may, actually, there was an additional 8 days credit time from when he was originally arrested. He was arrested out of county, and that wasn't able to be verified until today when I spoke to my client and then relay that information to the DA's office. I don't know if Ms. Abney was able to convey that to the prosecutors, but I know that she informed me that she was able to confirm that he had an additional 8 days, and the judgment now reads 103 days credit.
I didn't know that, but we'll get it.
Well, Mr. Manning says that he does have a judgment that says 103 days, correct?
That is correct, Judge.
He said that Miss Abney went ahead and provided that to him. So no objections?
No,
All right, then the court will award Mr. Mata 103 days credit towards his sentence for the time that he spent in jail on this cause. Anything further, Mr. Manning?
Nothing from the defense.
All right, Mr. Mata, you hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm gonna have you step over to be fingerprinted. Once you do get out of prison, Mr. Mata, if you've not paid off your fines, court costs, and fees, then you need to report to the courthouse, okay?
And Judge, the noise earlier was
Mr. Tatum?
Mr. Tatum. Judge, last time, I previously represented Mr. Tatum back in 2022. And so I'm aware of his mental health situation. It seems to have declined even since then. So what I'll do is I'll file an order to get him evaluated, and we'll see if we can't begin that journey again.
Do me a favor before you do that. Will you just also check to see if he is on any medications? I know he became competent while he was in custody last time, and I think it was due to the administration of medication. Will you check jail records, and I'll have Ms. Taberham assist in that when she gets back next week. But perhaps we can see if he is on medications now that he was on then, and maybe we can see if we have to get a doctor to prescribe those again.
Judge, if my recollection is correct, and it's been a minute since I looked at the specifics, but I believe Mr. Tatum only became competent after he was submitted to quite a lengthy stay at one of the state facilities where that medicine was administered. And if my understanding is correct, if my recollection is correct, he was only briefly competent for when he returned. I believe resolved his case with a time served plea previously. So I'm not sure. I'll speak to the DA's office as well and see what.
Just put him on suicide watch because he did something back.
And Judge, I'm being informed now that he's just been placed on suicide watch due to something that happened after court. So I'll expedite that process.
Okay, we'll go ahead and we'll reset both of these cases for arraignment and status on mental health competency. Let's set these on August 29th.
Yes, Judge.
All right, do you have anyone else, Mr. Manning?
Judge, I believe that concludes my business. May I be excused?
Yes, sir, you are excused. Thank you. Appreciate your work.
Thank you, Judge.
All right, I do believe that completes the court's afternoon docket. Court is going to adjourn at this time. Thank you, Deputy Martinez. Appreciate your help.